Friends, imagine buying a property through a registered sale deed. You pay full consideration. You register the document legally. Years pass peacefully. Then suddenly, after decades, someone comes to court and says, "This sale deed is fake. It was never meant to be a sale." Can a court believe such a claim? Can a registered sale deed be brushed aside so casually? The Supreme Court of India answered this question clearly in 2026.
Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today, we will discuss a very crucial legal question that affects every property buyer and owner in India. What happens if a registered sale deed is never properly challenged? Can it later be called a sham or fake transaction? What is the latest Supreme Court position in 2025 to 2026? Let us understand this through a landmark Supreme Court judgment delivered in January 2026. And this judgment is a game-changer for property law in India. Case details. This case arose between Hemalta, since deceased, through her legal heirs, versus Tukaram, since deceased, through his legal heirs and others. The dispute was civil in nature and ultimately reached the Supreme Court of India. The appeal was filed as a civil appeal, which originated from RSA number 163/2000. In this matter, the judgments of the subordinate courts and the High Court were challenged, as a result of which the case came up for consideration before the Supreme Court. The hearing of this case took place before the Supreme Court of India. The bench was constituted by Honorable Justice Rajesh Bindal and Honorable Justice Manmohan, who jointly delivered the decision in this dispute. The Supreme Court pronounced its final judgment in this matter on 22 January 2026. This judgment has been declared reportable, meaning that it can be cited as a legal precedent. The neutral citation of this judgment is 2026 INSC 82, which makes it officially recognized and referable. Background of the case. In 1971, the original owner Tukaram executed a registered sale deed in favor of Hemalta for valid consideration. On the same day, a registered rent agreement was executed, allowing Tukaram to remain in possession as a tenant. Tukaram paid rent for several years, clearly acknowledging the buyer's title. After a long delay, a civil suit was filed alleging that the sale deed was not genuine. It was only a loan arrangement. The document was sham and nominal. Findings of lower courts. Trial court held the sale deed valid and genuine. First Appellate Court confirmed trial court findings. High Court reversed the decisions, mainly relying on oral evidence, and treated the sale deed as sham. The matter finally reached the Supreme Court of India. Arguments before the Supreme Court. Arguments by the buyer, appellants. A registered sale deed carries a strong presumption of legality. Oral evidence cannot override a registered document under Sections 91 and 92, Indian Evidence Act, 1872, now Sections 90 and 91 of the Bharatiya Saksha Adhiniyam, 2023. The seller's conduct, payment of rent and admission of tenancy, supported the sale. Allegations of fraud were vague and violated. Order 6 Rule 4, Code of Civil Procedure, 1908. Arguments by the seller, respondents. The sale deed was allegedly executed only as security for a loan. Consideration was claimed to be inadequate. Possession, according to them, never truly changed hands. Supreme Court observations. 1. Presumption of validity. The Supreme Court categorically held a registered sale deed enjoys a very strong presumption of validity and genuineness. Registration is not a formality, but a legal safeguard ensuring certainty in transactions. 2. Heavy burden on the challenger. The burden to disprove a registered sale deed lies entirely on the person challenging it. Mere allegations, suspicion, or delay are not sufficient. 3. Oral evidence cannot override documents. Applying Sections 91 and 92, Indian Evidence Act, 1872, now Sections 90 and 91, Bharatiya Saksha Adhiniyam, 2023. The court held that oral evidence cannot contradict a registered document with clear terms. 4. Vague pleadings not permissible. The court reiterated that Order 6 Rule 4, CPC 1908 requires specific particulars when fraud or sham is alleged. Clever drafting cannot replace legal proof. 5. Mortgage theory rejected. No reconveyance clause existed. Requirements of Section 58, C, Transfer of Property Act, 1882, mortgage by conditional sale, were not satisfied. Hence, the transaction remained a sale, not a mortgage. Final judgment. Appeal allowed. High Court judgment set aside. Trial Court and First Appellate Court judgments restored. Registered sale deed declared valid, binding, and enforceable. Future impact of the judgments. Protects genuine property buyers. Prevents misuse of oral claims. Strengthens confidence in registered documents. Reduces frivolous property litigation. One-line legal position, 2026. A registered sale deed remains lawful and binding unless it is specifically challenged and set aside by a competent civil court with strong and convincing evidence. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.